Thank you for joining us for Smarter in 5. My name is Harmony Taylor, and I am an attorney with law firm Carolinas. Our firm has perhaps the largest community association law practice in North Carolina, with North Carolina offices in Charlotte, Greensboro, Wilmington, and the Triangle. Today, I will be speaking to you about handling human relations commission complaints related to fair housing matters. First, what they are. Various federal and state laws prohibit discrimination in housing on the basis of race, color, religion, sex, sexual orientation, family status, and disability, mental or physical. The Department of Housing and Urban Development, or HUD, has jurisdiction to investigate and enforce protections for individuals in housing matters. State courts may also have jurisdiction, and various localities have adopted ordinances that largely mirror the federal laws. Frequently, HUD will enter into contracts with state and local human relations commissions to handle the investigation and determination of these complaints. Once we know what the laws are, we need to look at how these laws apply to community associations. Community associations are prohibited from engaging in housing actions that discriminate against someone impermissibly based on one of the protected classes. The association cannot adopt rules that, for example, are targeted toward disabled persons or keep individuals from participating fully in the activities of the association on the basis of a protected class. If someone alleges discrimination in housing based on one of the protected classes, they can initiate a claim with HUD, a state human relations commission, or their local commission. Sometimes a claim initiated with one organization will be transferred to another for handling. Your first notice will usually be a letter sent to the registered agent of the association. The letter will briefly state the alleged discrimination and require a verified response with some period. In my experience, the response time is usually very short, approximately 10 days, and you will need to ask for more time, particularly given the fact that transmission is frequently delayed. It is imperative that you immediately acknowledge receipt of the complaint and seek additional time if that is needed. I've never had a commission refuse to grant a reasonable extension of time for a response. We could spend hours discussing the intricacies of handling a housing complaint and the pain associated with their handling. For today's purposes, I'm not going to focus on defensive strategies as they vary from case to case. I just want to share some best practices that should guide your handling. As I said, acknowledge the claim quickly and establish a good line of communication with the commission. Second, involve your attorney. You're not required to do so, but this is one area where you really don't want to go it on your own. 3, consider whether it makes sense to initiate a claim with the association's insurance carrier. Many policies don't cover these claims, but if they do, early reporting is imperative. 4th, notify the entire board and, if relevant, any prior board members of the claim. Sometimes prior board members are named parties and they need to be notified, as they will likely need to be part of the response. 5th, start to gather relevant information immediately. This will include a complete copy of your file, emails, letters, violations, etc., related to the complaining party. The commission is going to ask for this at some point, and you will need it at hand to prepare your response. 6th, do not take any retaliatory action against the complaining party. Likely this goes without saying, and you may be tempted to do so, but trust me, that will never work out well. 7th, go ahead and gather comparative data. If someone alleges that they were targeted for violations for failing to maintain their grass based on some protected class, pull other violation information for the relevant time period so you can provide some background to the commission as to how others were treated in the same and similar circumstances. 8, consider early resolution. If the relief sought is reasonable, you should strongly consider settlement. And last but not least, number 9, you must put aside your personal feelings about this matter. Board members are often hurt by allegations that they would or could discriminate. You may feel this, but you cannot react based on those feelings. This will undermine the response, and I can assure you that sworn statements that you would never discriminate are not going to help here. Discrimination claims are never welcome, but they are an increasing reality for community associations. It can be helpful to remember that they grew out of an unfortunate reality where individuals were and are being discriminated against, and they remain an important tool for those persons. If a claim is legitimate, treat it as such and do what you can to resolve the matter quickly and appropriately. If it is not legitimate, follow these best practices for handling, and you will place the association in its best possible position for successful outcome. Thank you very much.